Um, this is the last episode from the first week of the fall semester, quarter, whatever it is, that was canceled due to COVID. So because this doesn't involve cases, doesn't involve audience participation, I'm going to go ahead and record this one. This is class 5 on your syllabus if you're keeping score at home. And what we're going to do next Wednesday, which would be the 16th, is you're going to look at this before then. I understand it's going to be posted to Twin, so you know more about that than I do. At that class, we'll discuss, if you have any questions based on this class, this recording, and then we'll discuss some editing as well. And we'll also talking about the bills that you've been looking at for at least oral drafting. And those of you who, if you want the bills, those of you who are actual drafting, I'll send them to you, but I think I already did. At any rate, that will be the agenda for Wednesday. Right now, we're going to talk about drafting a bill. This is the preparation to draft a bill. Then we're going to be drafting the bill. First thing I'd do when I get the request is I would read it several times. Not do anything other than read it and think about it. And does this make sense? Is this a bill? Is this something that can be done? And then I jot down some notes on what I think has to happen, where I think it needs to go, what I think I might have to change, and other things that are going to come in handy when drafting, like what do I need to do? I better write that down so I don't forget it when I actually start writing, because that's easy to do as well. Then, if you have time, it depends on your time frame for the bill. If it's due in 10 minutes, well, pretty much none of this matters because you're just going to have to do the best you can. But we're assuming that the requester had enough forethought to have the due date a little bit beyond where you can actually think about it, do some research, and draft a bill that's appropriate for his request. So if you have time, assuming you have the time, I would do that. I would jot, and then I'd just wait to hold it to the next day. Just put it away, don't worry about it. And the next day I'd come back to it. The checklist I gave you, the bill preparation checklist, kind of assumes there's no stakeholders, there's no other parties, there's no co-drafters. It's just you and the request. Now, there are different scenarios under which you may end up drafting a bill, and we'll talk about those. But for the moment, this is just you. And so we need to get you prepared to draft the bill because you're not going to have any help. Then if you feel comfortable, the next day I'd read it again, see if you feel the same the next day as you did the day before. Often you will see something the next day you didn't see the day before, and you will see something that's not right from what you jotted down the day before. So it helps to have fresh eyes on it the next day without any real preconceived notions of what the bill does. And that's a trick from editing as well. If you think something says something, then you're probably going to read it that way. It's difficult if you did the drafting, if you knew what you wanted to say, it's difficult to look at it and say, that doesn't say that. That's wrong. So that's why it's always best to have somebody else review or edit it for you, but that's something we'll talk about Wednesday. So if you've got the notes the second day, if you think you know what it says and your notes are still valid, then it's time to start doing something. Not necessarily writing, but doing something. The first priority, the first thing you need to do is find out if the request is already the law. You'd be surprised how often that happens, that somebody will request something that's been the law for 10 years. You'll find if you do it a long time that there's not a whole lot of new ideas. It's basically a modification of old ideas, or modifications of not even modifications, just trying something again. So look at the old law and see if it's already there. If it's already there, you might want to circle back with your requester and show him or her what you have found. And upon doing this, my experience has been that several things may happen. First, the person can say, oh, well, that's good. Save me the trouble. Don't worry about drafting it. Second might be, well, that doesn't really matter to me. I want you to draft it anyway, which kind of means that it's being drafted for some reason other than becoming the law, but that's, once again, not your call. Or she might say, well, draft what you can that's not the law. There might be some things in this bill, this request, that's not in the law, so you can amend that law to add the new part of the request. But it's always to your advantage to know from the start what the law in the area of your request is. If it's not the same, there may be things that are identical, or there might be things you need to change in order to do this law, and we'll get to that. But you need to know the landscape of what you're drafting, what the law is, and what it's going to have to be to do what you want to do. Then you ought to discover where it's going to be placed in the code. Will it be a freestanding section that is not amending any present section, or will it be a new section, or it will amend an old section, or will it delete and replace an old section? A lot of that's going to depend on what you discover in the first step of what the law in that area is. Sometimes the law it's easier just to replace the existing law and put in the new law in your new request. In some cases, it's easier just to amend what the existing law is to add your request or parts of your request. Or if there's really nothing on that area, you will need to add a new section. But you'll need to know where you're going to put it, because it's got to go in the caption. And unless you know, your caption may be wrong to start with, which means your bill is going to be wrong, and you're going to have some explaining to do. An important part of drafting that's often overlooked is cross-references. Do a code search of the law you're going to amend. Is there cross-references to that law in other sections of the code? If so, you need to look at all those all the sections that it cross-references to the section you're amending, because it's going to cause mass confusion if you don't. Say, for example, you're amending 4-23-202 by deleting subsection B, and which would call a re-lettering of the subsequent subsection, so B would be gone. However, you find out that 45-34-298 says that something is going to happen as defined in 4023-202B. Well, 202B is gone by virtue of your bill, which means the 45-34-298 reference is going to be meaningless. Either you're going to have to go into the 45-34-298 and take out that reference, or you're going to have to re-reference it to what, if anything, the correct cross-reference will be. And if you've looked at it, you've looked at the law, and you still have no idea how to start it. Hardest part is starting it. And if you can't figure that out, what you might want to do is look in other states, see if they have similar laws. And some of the search vehicles by which you can do that, I have, or I'm going to provide, so you'll have those, I guess, Wednesday. Other states' laws could be extremely similar, and that will give you an idea how to start. However, you copy the other state's law and put it in Tennessee law at your own peril, because the other state's going to refer to things that are true in their state, might not be true in ours, or they're going to have definitions that refer to things that we don't have. And plus, you're going to have to look up what their references actually mean in the other state's law. So I think it's generally better just to get a plan from another state than to try to modify it. It takes a lot more time to modify another state to fit Tennessee than it does to do a new law based upon the other states. That's more of an idea of what you need to do than it is a blueprint for doing it. If you look at identical law in another state, it's not going to be like the Tennessee law, both references and probably terminology. But it gives you an idea what you want to do. And it may be you're in an office in a firm or someplace where there are people who specialize in the area of the law that you're drafting in. Sometimes, well, just kind of drafters end up taking a specialty subject matter just because it's too hard to draft in every area. There's too much to know. Like, I know very little about taxation, very little about county governments, and I wouldn't be qualified to draft a bill on that subject if it required some in-depth knowledge of that law. But you may have somebody in your office, firm, or whoever who does do that work and might be able to give you a quick primer on what you'll need to do to change that and what would happen if you change that. You may create unintended consequences you know nothing about, but somebody who does that work a lot would know about. And if all that fails, look back into past Tennessee laws, not the laws, but the bills. And I provided a mechanism to do that in the citation sheet as well. there is not much, from having done it a long time, there's not a whole lot of new ideas. At some point, most every idea was tried and either rejected or failed for some other reason, or it became the law. But most ideas are not new, and if you look back, and there's subject indexes by which you can do that, there are ways that you can get an idea of what's going on and maybe correct some of the mistakes that caused it to fail a long time ago or last year even. So you're ready to start now. You think you've got some idea of what's going on. Then you start looking at start filling out the checklist. And that's good to have in your backup materials in case you have to come back to it 2 weeks later and you've done enough stuff like slept and things like that since you did the bill that you don't really remember what it does as well as you did when you did it. So this is a checklist that will allow you to refresh your memory pretty quickly. And that's basically to write down the sections that are going to have to be in the caption. If you can do a brief summary of the request and citations of present law, well, you can look at the checklist, but all that's going to be important because you generally write your caption first. You might later amend your caption if you find something you have to do that's outside the caption, like one of those cross-references we discussed. So while you're filling that out, concentrate on the caption. And as we talked about a little bit last week, you can either do a broad caption, just Title 39 relative to criminal law. That way, you don't miss much. But as we also talked about last week, if you get into sentencing, is that criminal law? Or is that criminal procedure? That is something that I guess even I'm not completely sure of. And as we discussed last week, that might be a two-subject caption if it's criminal law. And then you do, or it might be outside the caption. If the caption's just criminal law and you do some sentencing provisions or parole provisions, that's not really, that's more procedural than it is the actual crimes. So be careful what you put in the caption and be sure it matches what you're going to have to do in the bill. And the good thing is you can switch your caption later and say relative to criminal law and criminal sentencing. That would pick up your sentencing if you wanted to do that. But that's going to be a broad caption. That's going to allow you to do what you want to do within the bill. But it's also going to allow other people to do what they want with your bill too. If they have something, as we discussed, that didn't work out too well for them, then they might try to amend your bill to include their bill. In which case, you've got something on your bill you don't like. Oftentimes, legislative courtesy, well, if you don't want that amendment on your bill, the membership won't put it on. But sometimes they do, especially if you're a minority party member, and minority meaning Democrat or Republican, and you are not in the majority of the General Assembly. Right now, there's a lot more Republicans than Democrats. So if you're a Democrat and you've got a bill, and Republicans start using your bill to do things that they want to do that didn't pass in their bills or they just thought of, then there might be a very slim chance of you not getting that put on your bill. If you do, you're either going to have to live with it or you're just going to have to withdraw your bill. Once it's on, you have pretty much lost control of it, and there could be a lot of things. And they could put things on, somebody could put something on by amendment that has a physical cost, which means your bill's going to have to go to finance. You find yourself in finance trying to defend a cost that you didn't want to start with. Generally what happens in those cases is that bill is just dead. You withdraw it or take it off notice, so it's dead for that General Assembly, that session anyway. So that's something you want to think about if you're having a broad caption. If it's something everybody agrees to, then that's fine. You can have a broad caption. Or, if you're if you're somebody that is a specialist, has particular knowledge in that area, then you can probably fend off any questions, any attempted amendments by saying, well, that's going to be broader in my caption, that's going to ruin my bill, and you'll probably get away with it because you're trusted and you know more about your subject than most anybody else. Or you can have your narrow caption, as we talked about, where you just put 39-1307B. That's all you're going to amend. It's just subsection B. That will keep off other amendments, but as we spoke of, that will also limit what you can do. If you find a cross-reference to subsection B that you would really like to change, you're pretty much stuck, and that bill is going to be worthless because the caption is too narrow to take another bill section. And that was the purpose of it until you found out you needed another bill section to amend, and you don't have it. Or you wanted to add a section that supplements or provides procedure for the subsection B which you're amending. You can't do that either unless you can stick it under B as well as what the substance of the bill was. And when you're doing the bill, and this I'll get into, this goes to the various ways in which a bill gets drafted. Think about, well, who's going to be against this? Who's going to be for it? Think about how the bill is going to be received, not necessarily by the press or the public, but by people who have an interest in that. Might be what we call stakeholders that would have an interest in the outcome of the bill, their industry or their business or something. So think about that ahead of time so you're not hit blind with that. I guess this would be a good time as any to get into the various type of meetings, various type of bills being drafted. We have been talking about a bill in which you're the single drafter, and nobody else really knows what the request. That request hasn't even been made. Another scenario is the requestor tells you to get with X, who may be a lobbyist, who may be a departmental employee, who may be an attorney, outside attorney, and see if you can get a bill drafted on this subject. Well, that means that whoever you're drafting with is going to know more about the subject matter than you probably, but you're going to know more about the drafting. Most people in the real world, stakeholders, they don't know too much about drafting. They just know what the law in that area is, what their interest in that law is. So it would behoove you to learn as much about that law as possible so that when you start meeting with that person, you don't get hoodwinked into doing what they want to do as opposed to what the requester wants to do, the intent of the bill. You don't want to be swayed. You don't want to be in a position where you just don't know any better than to say, okay, we'll do it that way. You need to have at least enough knowledge of the subject matter that you can say, wait, I don't think that's true to the intent of the bill. I think that will be good for your industry, but that's not what the bill does. In which case, you may find it very difficult to draft with this person unless they are also somewhat willing to compromise, and most of them are. Most of them, unless they're just totally against it, most of them are willing to compromise some, and even the totally against it, you can probably work out something. But you're not going to be able to work out something unless you know enough to say no. You know enough to say, let's do it another way, let's do it this way. But what about this case? You got to know enough to dispute their probably superior knowledge of that area of the law. And if you can do that and they understand that you know more than that you know something about it, then they're much more likely to play along and compromise to some degree. And then you're probably you need to be the person who drafts the bill. Don't let the department employee, don't let the private attorney, don't let a company representative draft the bill. You draft it. That's your job. You know more about it. And for reasons we'll explain later, it's important that you be the one who drafts it. There is another scenario that's more mass confusion, but it's stakeholders. There's more than one. There's a bunch of them that either don't like your bill, don't like the request, or want it to say something else. But you might have anywhere from 5 to 20 that have some interest in the bill and want to be heard. They have a stake in the bill, as it were, and they want to be heard and they want to have input on the drafting. So generally, y'all get together in a big room and you talk about the bill. What can be done, what can't be done, what their interests are. And you would probably be wise at this point because all those people are going to know more about it than you, probably. So just take notes, just listen. This is where you listen. This is where listening is very important. And take notes of what they're saying and take notes of what they're saying they want to do, they're saying they can live with, what they're saying they cannot live with. That way, later on, and you, like you say, don't say anything and just wait till it's all over. But then you interject, well, I've got some notes. I think I know what you all want. I think I've listened to your concerns. Let me go write the bill and we'll get back together. Which is to say, you write the bill. You don't turn it over to one of the stakeholders who fancies him or herself a drafter or an attorney who drafts pleadings but not bills. That's totally different. And if you've seen a pleading attorney draft a bill, that's where you get the wherefores and all the legal language that makes the bill incomprehensible. But you draft the bill. There's reasons for that. You want your words, your ideas, to be the words on paper. Generally speaking, the person who gets something on paper has a distinct advantage. That way, when you get back together, everybody is working off your words, your ideas, your thoughts. So they're having to, even though it's not what they want to do, it's here, let me see what I can do, let me see if I can change it any. But you want to control the narrative, you want to control the language, you want your language in the bill. You want your language to be the language that everybody works from, not somebody else's. If somebody else does it and you don't think it's what you want it to be or what your requester wants it to be, then it's going to be hard at that point for you to say anything. But if it's your language, you can control, and everybody's working off what you're doing, what you did. Now, if they have suggestions or they have comments or they have amendments or things like that, if you can put some of those into the bill without completely screwing up the bill or the intent of your sponsor, that's definitely to your advantage to do that. That way, when you come back, you can say, well, this Section 3B addresses your concern, so I'm assuming you don't have any problem with it. And maybe even if they want to submit some language, if it's not complete gobbledygook, you can work it to where it makes sense, and then you can go back to the meeting and say, this is what you wanted in drafting style. And most people in one of those meetings are not going to be able to dispute that, and they're just going to accept it. And for the most part, there's not going to be anybody in those meetings that is going to want to redraft it. That's going to be a lot of trouble. So probably they're going to accept what you did rather than try to change it. Try to redo it, not change it. And if they try to change it and you can put in some changes, that's good, because that puts an investment, that makes them invested in the bill, makes them invested in the language of the bill. And later on, if they object, you can tell your requester, well, this is what they wanted, I put it in for them. This is new to me, that they still object. The maxim for group meetings is he who puts the bill on paper first kind of controls the direction that the bill is going to go. So you want to be the first on paper. If you think somebody's going to be the first on paper or somebody else is going to bring a draft, you have a draft before you come to the first meeting. And that's probably going to be a good idea anyway. Do what you think it's going to say, what you want it to say, and bring it with you. That way, if things look pretty close, you can take it out and say, well, I think I've got this, got this fixed, and everybody can agree to it. And they might not be that invested in the bill, they might not care that much, or certainly don't want to redo it. So it's always a good idea to have something in your back pocket. You don't have to disclose it. You can just sit and listen. But if it's something that is something you should think about and bring with you, just in case there's an opportunity to pull it out. And if that's the case, maybe you can end this discussion real quickly. And by endless discussion, these stakeholder meetings can happen twice a day for a week sometimes. It just goes on. And if you've ever seen the group dynamics, there's a lot of people that just like to talk, that are not being particularly helpful to the subject, but they like to talk about it. and they like to show how much they know. So you end up burning a lot of time in meetings that are not very productive, which is why if you can, as early as you can cut off those meetings, the better it'll be. If everybody agrees to it, then it's fine. Then the requester's happy because it won't be that difficult to pass if everybody agrees to it. As far as the actual drafting, of course, start with your caption and just kind of think through the order. What do you want to do first? And you've seen it's actually in the editing, and I'll send you that before Wednesday. But when you're editing, you kind of go through it, and it's write everything down, because at some point you might have to prove later what the notes of the bill. Sometimes their backup notes have been used in court to show the intent. So don't write scribbles that might not look good in court on your backup material, and just think through how it should be done, the order of battle, so to speak. And of course, as we've said, you want your whereas clauses, and you know the order. Whereas clauses are something I generally do last, because they're an attempt to explain the bill in the bill. They're not codified in a bill. Anything above the enacting clause, that being enacted by the General Assembly, is not codified. And anything below it is codified. That's the actual part of the bill. So generally those whereas clauses, and we'll show you examples of those, and even the short title are often not codified, which means they go above the enacting clause. But I generally do whereas clauses later, because if you do them first, you might end up doing the bill and they don't explain the bill because you've changed it. So you want to explain what you've done, not what you think you're going to do. So I'd skip that part till the end and just get your order and use words that are plain and simple. Not the time for legalese. We'll discuss at a later class word usage and somewhat in editing, but just be simple. Just have plain language. Avoid unnecessary words. And there's a whole list of unnecessary words, like under provisions of so-and-so. Just say under so-and-so. You don't need the provisions of. Just takes up words. Unless you're getting paid by the word, then you might want to pull out your legalese, but generally they're not. So keep it simple. Stupid is a good motto for a bill. Sometimes you can't keep it simple. And I'll show you examples of where it should be kept simple this upcoming Wednesday. But the bill is just make sure you cover everything. Make sure it's in a logical order, that you don't want to be amending something first that later on in the bill, that is out of sequence. So you look at that first and the rest of the bill says something else, and you wonder what that first section was all about and why it's there. That's generally you get your substance first, and then you do your cleanup by amending other sections of the code that you need to amend, by fixing cross-references because a lot of people don't look at the end. That's generally reserved for administrative code cleanup. Sometimes if, you're crafty, you can slip something in towards the end that might not be caught by stakeholders. But that's not really ethical drafting. That has been done, but not something I'd recommend. So make your substance, make people that read the bill know what it's doing from the start. Make them able to tell from the first section. Give them a general idea what the bill's going to do. You can get more specific later. And, well, that depends on whether you're creating a new section or not, but especially if it's a new section. If it's an offense, of course you're going to have your mens rea and you're going to have your elements first, and that's going to be the most important thing about the offense, and that's all going to be probably in the first section. Now, once I have drafted a bill, I do the same thing as before I started. I would just put it aside unless you don't have that kind of time. If it's a stakeholders bill, I wouldn't send it out to anybody at that time. I would wait until the next day at least, unless there's some kind of absolute deadline. I'd wait till right before the deadline. So I'd want to see the bill again fresh. I'd want to keep in mind, if you can put in from the start some of the things the person's a stakeholder or somebody's going to object to or going to want to see in the bill, then you may be way ahead because you can, at the next meeting, say, well, I've already done that. That's already in your bill. And that might, unless they've prepared something, that might make them think, well, okay, I'll just leave that because it's more trouble to have to write something different. And they don't know what they're doing drafting generally than it is to just accept yours. So look ahead and try to anticipate objections, try to anticipate scenarios, unintended consequences. It's just long before most people's time. Back in the old Saturday Night Live days, there was an episode called What If Eleanor Roosevelt Could Fly? And that was all these serious news and army brass and important people sitting around a room trying to come up with scenarios of how they could utilize Eleanor Roosevelt if she could fly. Now, maybe a stupid example, but I use that because you need to sit around and you need to think of every crazy scenario that could be happening under that bill. And then see if it's covered. If it's not covered, then it's going to happen. If it can happen, it probably will happen. And if your bill doesn't cover it, then it's going to happen it's going to be unregulated or uncontrolled, or people are going to think that subject is taken care of, and it's not. You're going to get into court, and there's going to be something that comes up that you didn't anticipate. Of course, you can't anticipate everything, but if you just sit and look at it, and think about the strangest things that could possibly happen, then look at your bill and see, is that covered? And we'll discuss some of that in the bills you're looking at for discussion this Wednesday. There's some things in it that on their face look like it's taken care of, but it might not be. What if? Always play what if with your bill until you think you've covered everything. And if it doesn't, you need to change your bill. You need to include that, because you can count on that happening at some time to someone, and everybody gets to court and they find out, well, that bill doesn't cover that at all, so it's a terrible mess. You don't want to be the author of a terrible mess. You want to have anticipated, so they say, oh, well, they did think of that. It's down here in subsection C. Good. That's taken care of. Everybody go home. So the front end is the time you anticipate these unintended consequences. If it's an unintended consequence and it's not a good one, then you need to change it. You need to change your bill to prevent that consequence from happening, or to make sure your bill has nothing to do with that consequence. Because if it does and your bill causes it, then that's not going to go well for the drafter. Believe me, that's happened. And whether you can anticipate anything or not, you can anticipate a lot of things that most people don't. It's surprising how many people draft bills and never really think about, well, what if this happened? And does this bill cover that, or is it not going to be against the law if I do this? That's something when they come back to you and say, well, this just happened, and the DAs are saying they can't charge this person because the law doesn't cover that. And why doesn't it? And I thought we were supposed to be covering it. That's difficult to explain as well. So go through that series of thought process. What if? What if? Is it covered? If it's not covered, cover it. Then just look technically at the bill. Is everything in the right place? The definition's in the right place. And you're going to get a lot of that based on the editing bill I'm sending you. Not the bill, but a checklist. That will give you something about order, about what to do, how to thoroughly vet a bill before you send it out. And I would do all that before I would send it to interested parties. If you send a sloppy bill to an interested party, then you lose your credibility and the requester's credibility that he would have you draft such a disaster. And you would be, from that point on, pretty much irrelevant to the conversation, and you will not have done your job for the requester. So you make sure you're comfortable with it before you send it anywhere. Now, and that includes the requester. There's a good chance if you give it to the requester, people are going to be calling him, her, whoever requested it, wanting to know, can I get a copy of that? Have you seen that draft yet? And probably the requester is going to send it to them. So unless there's an absolute deadline, I would not send it to anyone, including the requester, until I was extremely comfortable with it myself. Now, some things you're not going to see, and some things you're not going to know what you don't know, to quote the Donald Rumsfeld. Sometimes you're going to get in that meeting and they're going to come up with a scenario that, well, it's not covered because I didn't know. I didn't know anything about that. That's where your knowledge of the subject matter will be helpful. And if it doesn't cover something it ought to cover, admit it and say, yeah, we can fix that. I'll take it back and fix it. Don't let them fix it. Say, I'll take it back and fix it. And do that and send it back. And that way, once again, they will think you have done what you asked to do, what they ask you to do, and that you're trustworthy. You're not trying to pull something over on them. And that's important because shareholders, stakeholders, outside attorneys, anybody like that can pretty much ruin your reputation and sometimes even your job security if they go back, if they start talking about things you didn't do, that you're trying to pull something over on them, that you're trying to bamboozle them into something they gave you something and you didn't do it correctly, or so, play along with them. Do the best you can to respond to their concerns while at the same time maintaining the intent of the sponsor, the requester. Sometimes you don't know that, but you can gather from the request probably what they're trying to do. If not, then you are going to have a difficult time anyway trying to draft the bill. Some of it gets some of this gets into editing, which we'll talk about, and some of it's just simple you proofing the bill, you editing, and as far as editing itself, it should be done by somebody else, and we'll talk about that. You shouldn't edit because I spent summers as a proofreader, and your mind can control what you read. I mean, if you look at something and think, well, that says this, you overlook that it doesn't say that you got a typo or something like that. So it's better to have somebody else reading it. And let's see, is there anything else that we need to talk about before? I'm going to kind of abbreviate this class because we're going to have to talk about this class and editing in the next class, plus your bill request. Talk about them. And those of you who are actually drafting a bill may have questions about that as well. Hopefully, as in most things, the key to drafting is preparation. To know what you don't know and that what you think you know is accurate. If you're prepared, the writing part is not as difficult. Now, the writing part, saying what you want it to say, is kind of an art because it's kind of a different language. It's not lawyer language. Most lawyers, even the good ones, can't draft. And that should be of some comfort to you if you're having trouble drafting. That's some people that are very well respected in the legal community can't draft at all. It's just not something they do. It's a different language. So if you start now, if you do some beforehand, when you get to be an important person in the community, you can draft. You can attend meetings and know what you're doing drafting-wise, so you don't have to depend upon who that drafter is at the time. And you can probably make money drafting, because a lot of times companies, businesses, special interest groups, they want somebody. That's what public relations attorneys are with those groups. They will either work on the drafting or they will oversee the drafting. But if you can draft, then you're going to be very valuable to those companies, because they would prefer not to have somebody like me drafting who is not going to draft exactly what they want. That's not my job. That's the job of their public relations person. So if you can be a public relations person and an attorney and have some drafting knowledge, that's going to make you more valuable in the real world. Same with departments or anything else. Department people don't draft real well. Some of them do. Some of them who've been there a while are very good at it, but that's not what they do either. And that's probably not going to be what you do. But hopefully by taking this class, you'll be ahead of most of them, because most lawyers coming to law school don't have any idea about drafting. That's where this class should put you ahead of those lawyers coming out of law school. It's just, to use an expression I hate, one more tool in the toolbox that you can draft. I guess as far as drafting, be complete, know what you're doing. Make sure you've checked all your cross-references. Make sure you don't leave something open. Make sure there's no unintended consequences with your bill that you can possibly determine. Make sure that it's simple, it's plain. As we'll find out in a couple of weeks, if it's plain, if it's simple, if the words, if given their plain meaning, the words make sense, then the courts are not going to interpret them. That's one of the primary rules of statutory interpretation. They won't interpret a statute that's plain on its face. It has a clear meaning on its face. And that's exactly the posture you want to be in. If you have a court interpreting your statute, then you did not draft it very well, because they don't know what the request was. They don't, they've got their own jobs. They don't know what was going on when you drafted that. They don't know what the problem was. They just know what's on the piece of paper. They'll look back at legislative history and tell what they can tell, but most of the behind-the-scenes meetings and things like that are not in legislative history. They're not written down. That's where you have the advantage. So if a court is interpreting, they're doing it on grounds. They're doing it on statutory rules of interpretation, which we will get to, but that's not what you want them doing. You want them saying, oh, well, this is clear in its face, this is plain meaning. We don't need to go any further. It is what it is. It says what it says it says. So we'll just decide the issue based upon the language. That's what you want, and that's why you got to be precise. It has to be something anybody can read and have some idea what's going on. And most of the legislators who are going to be voting on these bills are not attorneys. In fact, fewer and fewer are attorneys. They range from, there's some doctors, there's some insurance salesmen, there's some farmers. There's a lot of folks that don't know as much as you now know about drafting. And your bill is going to need to be clear enough, plain enough, simple enough that these people can read it and understand to some extent what you're saying. If they can't, then they're going to feel like you're pulling something on them, or they're just going to be reluctant to vote for something they don't understand. So start out with it in mind that you're going to be comprehensive in your code searches, and you're going to be comprehensive in looking at other. There might be one thing you need to know is there's federal law on that subject. And if there is the federal law preempted the state on that subject? If they do, then you need to tell somebody that as well, because it's not going to work the way you want it to work. Like firearms, a whole bunch of the firearms law, even though we have a lot, is preempted by federal law. Like who can buy a gun, what age you have to be, what the disabilities are where you can't purchase or possess a firearm. Those are in Tennessee law, but they're based on federal law, which is the at least minimum for that area. You can make it more stringent, but it has to be that baseline. So check federal law. Also, you need to check the state rules and regulations. Departments tend to put a lot of things in regulation that ought to be in law. And they may do that for a reason. They may do that because they don't quite know what the law is in that subject. So check with theirs. I mean, there's a way. There's an administrative registry that has the rules and regulations of each department. And if you think there might be a rule on something, you ought to find out. If there is, you should see if your if your bill is going to conflict with it, or if it's compatible. Generally, a statute is superior to a rule. So if you can't repeal the rule, but you can supersede it by statute. You can say despite any rule or regulation to the contrary, this is going to be the law. Oftentimes, overreaching departments or departments deemed to be overreaching there's a statute passed to kind of bring them back down, back within the boundaries a little. They might be doing something outside of their scope. And so you have to pass a statute. And if you do that, you better know if there's a rule there or not. Especially if you get in court. If you have a statute and then there's a contrary rule and that's not mentioned in the statute at all, then the court's going to be confused too. They're probably going to accept the statute, but it's going to be, once again, it's going to cause confusion. So know what's out there before you draft. That's the basis of the research. Know what you're getting into. Know what you can do, know what you can't do. And of course, there's constitutional limitations to almost anything you draft, and that's something we have briefly discussed. That may not matter to the requester, it may matter to you, but that's not a reason to not draft the bill, because there may be considerations you're not privy to that the requester wants that bill, even though it may be unconstitutional, and everybody may know it's unconstitutional. If there's a way you can draft it and make it constitutional, or at least arguably constitutional, defensible, then you probably ought to do that if you can, and hopefully that will work. That will still be an effective statute, even with the constitutional provision. I guess if I had to take away from this, be prepared. Don't draft immediately unless you have to. Think about it. Write notes. Then start looking for present law. First thing, present law. Is there a present law on that subject? You may save yourself some work, or at least you may know what you're dealing with. Compile all that. Get an idea of what you want to do in the bill. Look at your checklist that you have filled out concerning the bill. And draft the bill plainly, simply, so that almost anybody can understand it. Now, there are going to be terms of art, especially in criminal law, especially in almost any area of the law, that you are not going to be able to get around, but probably they're going to be defined, and if they're not going to be defined, you ought to define them in the bills you're looking at for oral discussion on Wednesday. There are things that need definition, so if you look at something that's not clear to you, it's not going to be clear to whoever's reading it. So define it. And that way you can define it how you want it. So everybody's, once again, playing by your definition. People can't say, oh, well, it doesn't say that, it doesn't mean that, it means this. Well, not if you've defined it for purposes of your law. It means what's in your law. They may change that, but for the start, it's going to mean what you define the term to mean. However, you can't define a term to mean something that's plainly contrary to the simple dictionary meaning of a word, but you can nuance it some if you need to. But the first thing is make sure everything's clear. Make sure it's not the present law. Get your ducks in order before you start writing. You're wasting your time if you're just shooting off the top of your head. I guess that's shooting from the hip. Shooting off the top of your head doesn't sound good. But you need to know what you're going to do before you do it, or else you're going to be doing a lot of drafts, which also happens. I mean, I've done 10 drafts of a bill. I think it's good. I go back, read it again. It's not good. Do it again. Kind of the rinse and repeat process until you officially get it how you want it. But the best thing is not to do that. The best thing is to know what you want to say before you say it, and then write it as easily or simply as possible. Me and my voice are probably going to let you go out early at this point because we're going to have a lot to do on Wednesday based upon what you've heard today. I'm sure you're going to have questions on what you've heard today. And then we're going to look at some editing practices and discuss your bills that you're mentally drafting. And be prepared to discuss those bills, because this is in lieu of, it's not graded, but it's in lieu of having an actual written draft if you're not some of those who have requested an actual written draft. So with that, I'll let you go until Wednesday, and I'll see you and be prepared to essentially cover 2 classes in the Wednesday session. So good night. Well, it's still good now. It's good afternoon to you now. So we'll talk again 2 days from now.